Welcome to The Political Bridge, the podcast where we explore complex issues from multiple perspectives. I'm Ada, your host. Today, we're tackling a highly charged and critical topic, the potential for a federal red flag law. These laws, also known as extreme risk protection orders, allow temporary removal of firearms from individuals deemed a danger to themselves or others by a court. While proponents argue they are a vital tool for preventing gun violence and suicide, critics raise significant concerns about due process, constitutional rights, and their overall effectiveness. We'll examine whether a federal red flag law represents an effective and constitutional approach to gun violence prevention. Joining me to dissect this issue are Nico, our conservative voice, and Jordan, our progressive voice. Let's dive in.
A federal red flag law, while ostensibly aimed at public safety, presents profound constitutional and practical challenges. The Fifth and 14th Amendments guarantee due process, yet many state-level red flag laws permit ex parte orders, meaning firearms can be seized before the gun owner even has a chance to appear in court and defend themselves. This is a clear violation of fundamental rights, including the right to bear arms under the Second Amendment, by shifting the burden of proof onto the accused to regain their property. Furthermore, the criteria for determining dangerousness are often vague, leading to subjective interpretations and potential for abuse. We've seen instances where these laws are used vexatiously. Instead of infringing on the rights of law-abiding citizens, we should focus on enforcing existing laws, addressing mental health crises with robust treatment options, and ensuring swift justice for those who commit crimes. A federal overreach would only exacerbate these issues, creating a patchwork of inconsistent applications and eroding trust in the legal system without demonstrably improving safety. The focus should be on individuals who pose a clear and present danger, not on preemptive seizures based on subjective predictions.
The evidence overwhelmingly suggests that red flag laws are a crucial and effective tool in preventing gun violence, particularly suicides, which account for the majority of gun deaths. Studies, including one published in the American Journal of Public Health, have shown that these laws are associated with a significant reduction in gun violence, with one study estimating a 13.7% reduction in firearm suicides in states with such laws. They provide a mechanism to intervene during a crisis, often before a tragedy occurs, by temporarily removing firearms from individuals who demonstrate clear warning signs of impending violence. This is not about permanent confiscation, but a temporary measure, subject to judicial review and due process, to de-escalate dangerous situations. The process typically involves a court order initiated by family members or law enforcement based on specific, articulable facts. This is akin to a restraining order, which has long been accepted as constitutional. A federal framework would standardize best practices, ensuring robust due process protections while empowering communities to act decisively when someone is at imminent risk. It's a proactive, evidence-based approach that respects both public safety and individual rights, providing a critical intervention point that current laws often miss.
Nico, you've raised concerns about due process and the potential for abuse, citing ex parte orders and vague criteria. Jordan, you've highlighted the effectiveness of these laws in preventing suicides and other gun violence, emphasizing their temporary nature and judicial oversight. My first follow-up question to both of you is this: how do we reconcile the constitutional right to due process with the urgent need for immediate intervention when an individual poses an imminent threat? Is there a model for a red flag law, either existing or conceptual, that you believe strikes the appropriate balance between protecting civil liberties and ensuring public safety, or are these two objectives fundamentally at odds in this context?
The reconciliation lies in prioritizing robust due process from the outset, not as an afterthought. An appropriate balance would require that any red flag law mandates an immediate adversarial hearing where the gun owner is present and represented by counsel before any firearms are seized. Ex parte orders, by definition, deny this fundamental right. If there's truly an imminent threat, existing laws like involuntary commitment for mental health crises or emergency protective orders can be utilized, which often have more stringent due process requirements. The challenge with red flag laws is their broad scope and lower evidentiary standards compared to criminal proceedings. A truly constitutional model would require a very high standard of proof, such as clear and convincing evidence of imminent danger presented by law enforcement, not just an aggrieved party, and subject to immediate judicial review with the gun owner present. Without these safeguards, we risk creating a system where rights are eroded based on speculation or malice. We must not sacrifice constitutional principles for perceived safety gains, especially when less intrusive, more constitutionally sound alternatives exist.
Nico's concerns about due process are valid, and any federal red flag law must incorporate robust safeguards. However, the idea that ex parte orders are inherently unconstitutional in emergency situations is a mischaracterization. We have precedents like temporary restraining orders in domestic violence cases, where immediate action is taken to protect victims, with a full hearing to follow swiftly. The key is the swiftly follow part. A well-designed federal red flag law would mandate an initial ex parte order only in cases of genuine, imminent danger, requiring a high evidentiary standard for that initial order, and crucially, scheduling a full adversarial hearing within days, typically 72 hours, where the gun owner can present their case. This isn't about permanent confiscation. It's about a temporary pause during a crisis. The goal is to prevent immediate harm, allowing time for a more thorough judicial review. Several states, like Connecticut and Indiana, have implemented these laws with strong due process protections, demonstrating their effectiveness without widespread constitutional challenges. These models show that public safety and due process can indeed coexist, especially when the focus is on temporary emergency intervention.
Jordan, you've pointed to existing state models that incorporate due process. And Nico, you've emphasized the need for immediate adversarial hearings. Let's consider the practical application. For Nico, how would you address the argument that waiting for a full adversarial hearing before any action is taken could mean the difference between life and death in situations of imminent threat where an individual has expressed clear intentions of harm? For Jordan, how would you respond to the concern that even with a swift follow-up hearing, the initial ex parte seizure of a firearm, a constitutionally protected right, sets a dangerous precedent for government overreach and could be ripe for abuse by those seeking to disarm individuals based on personal animosity rather than genuine threat?
The argument that waiting for a hearing is too slow often overlooks existing legal avenues. If someone expresses clear intentions of harm, especially towards themselves or others, law enforcement already has the authority to intervene under existing mental health commitment laws or by making an arrest if a credible threat constitutes a crime. These interventions can temporarily remove the individual from the dangerous situation, which is often more effective than simply removing the weapon while the dangerous individual remains at large. The focus should be on the person, not solely the object. Furthermore, the risk of false accusations and the permanent stain on an individual's record, even if the order is eventually overturned, is too high. We must uphold the principle that an individual is innocent until proven guilty, and their constitutional rights, including the Second Amendment, should not be suspended without a full and fair hearing. Prioritizing due process ensures that interventions are based on verified facts, not just suspicion, and prevents the weaponization of the legal system against innocent citizens. We cannot compromise fundamental rights for potential unproven safety gains.
Nico's concern about potential abuse is precisely why robust due process protections are essential within a federal red flag framework. The law must clearly define who can petition for an order, primarily law enforcement and immediate family members, and require specific, articulable evidence of dangerousness, not just personal animosity. Furthermore, penalties for false petitions should be severe. Regarding the dangerous precedent argument, as I mentioned, temporary restraining orders and emergency commitments already exist and are widely accepted as constitutional tools for immediate crisis intervention. A red flag law is an extension of this principle, specifically tailored to firearm removal, with the critical safeguard of a full hearing within days. The data from states like California and Florida, which have implemented these laws, show they are used judiciously, primarily in cases of clear crisis. They've been instrumental in preventing mass shootings and suicides. It's about giving communities a tool to act responsibly and prevent tragedies, not about government overreach. The alternative is often inaction, leading to preventable loss of life. We must empower responsible intervention, not paralyze it with fear of hypothetical abuses.
We've had a truly insightful discussion today on the complexities of a federal red flag law. Nico, you've made a compelling case for the primacy of due process, highlighting concerns about constitutional rights and potential for abuse, advocating for existing legal avenues and robust, immediate adversarial hearings. Jordan, you've emphasized the life-saving potential of these laws, particularly in preventing suicides, and argued for a framework that balances immediate intervention with strong due process safeguards, drawing on successful state models. It's clear that finding common ground on this issue requires a deep understanding of both constitutional principles and the urgent need for effective gun violence prevention strategies. Thank you, Nico and Jordan, for shedding light on these critical perspectives. To our listeners, we encourage you to continue this conversation responsibly and thoughtfully. You can find more information and resources on our website, thepoliticalbridge.com. Join us next time as we continue to bridge the divides in our political landscape. Until then, stay informed and engaged.